Tantor Audio, a division of Recorded Books, presents The Jury, a very short introduction by Renée Lettow Lerner, narrated by Cathi. Introduction. Two well-known movies about the jury, made 5 years apart, portray the institution very differently. In the 1957 film 12 Angry Men, jurors in New York City have to decide on the guilt of an 18-year-old charged with murder. The judge tells the jurors that if they convict, the sentence will be death. The verdict must be unanimous. After the first 3 minutes in the courtroom, the rest of the movie shows the deliberations in the jury room. At first, the jurors are convinced that the evidence is overwhelming, and all vote to convict in an initial vote. Except one. Heroic Juror 8, played by Henry Fonda, persuades his fellow jurors to deliberate thoroughly. In the process, the jurors reveal their different personalities and backgrounds, and scrutinize each bit of evidence. They examine a diagram of a witness's apartment and conduct an experiment, timing the witness's alleged movements to see whether they matched his testimony. An immigrant juror tells the others, "We have a responsibility. This is a remarkable thing about democracy." After hours of deliberation, the jurors all vote to acquit. The American Film Institute chose 12 Angry Men as the second best courtroom drama of all time. The best was the 1962 movie To Kill a Mockingbird. That film is based on a novel of the same name by Harper Lee and is set in the fictional town of Macomb, Alabama, during the early 1930s. Lawyer Atticus Finch, played by Gregory Peck, is defense counsel for Tom Robinson, a black man accused of raping a white woman. Atticus talks to his young son about what real courage is. It's when you know you're licked before you begin, but you begin anyway, and see it through no matter what. Atticus knows he is defeated before the trial even begins, because no jury at that time and place would acquit a black defendant of such a crime. The jury is all white, as black people were systematically excluded. At trial, Atticus destroys the prosecution's case, but the jury convicts nevertheless. The jury can be inspiring, even romantic. We, the jury, is the stuff of novels, movies, shows, and video games. The word conjures images of Magna Carta, liberty, self-rule, the wisdom of crowds, and ordinary people's common sense serving as a check against self-interested or out-of-touch elites. But the jury also has a dark side. Juries may be biased or confused by the law and evidence. Citizens do not always welcome a summons for jury service, and many try to get out of jury duty. By necessity, modern legal systems are set up on a professional basis, with the need to decide complicated questions of fact, and some aspiration to apply the law in an accurate, predictable way. This book will show how many societies around the world, ancient and modern, have used lay juries, and how they have tried to resolve the tension always present between predictable law and popular justice. This tension has grown over time because of greater specialization and knowledge. Often, specialists, lawyers and judges, have co-opted juries for their own purposes. They have used juries as cover for furthering their interests. Jurors are laypersons, meaning that they are not professional judges. Lay comes from the Greek laikos, of the people, as opposed to a member of the clergy or a body of professionals. The word juror comes from the French word jureur, a person who swears an oath. All jurors take an oath or make an affirmation to decide the case fairly. Professional judges have no need to take an oath in each case. When they became judges, they took the judicial oath of office. Lay jurors have no durable office, and so they need to be sworn, in effect, as temporary judges. the oath that jurors take for criminal cases in federal courts in the United States, is some version of, "Do each of you solemnly swear, or affirm, that you will well and truly try, and true deliverance make, in the case now on trial, and render a true verdict according to the law and the evidence, so help you God?" This oath is close to the one administered to English jurors since the Middle Ages. In the oath, the word true appears again and again. In fact, the word verdict means a true saying. Such repetition suggests concern. Although many societies have used juries, the jury, as it exists today, is a direct descendant of the medieval English jury. The institution is a defining characteristic of what is known as the common law system. The common law system is the name for the family of legal systems used in England and Wales, and former British colonies including the United States, Canada, Caribbean countries, African countries, New Zealand, and Australia. Around the world, only former British colonies have adopted the common law system. In Europe, the English common law system was a strange anomaly. The main family of Western European legal systems is known as the civil law system. In this context, the civil law system does not mean a system for dealing with civil cases only. The term refers to the entire legal system, both civil and criminal. The civil law system developed mainly in the Roman Catholic Church, and then spread to secular governments. That system traditionally used professional judges instead of lay jurors to decide cases. It is known by other names, including the inquisitorial system, or the Roman canon system. It has spread around the world to Latin America, Africa, and Asia. A major theme of this book is the contrast between the common law and civil law systems. Many countries with civil law systems are now trying to use lay decision-makers. They do so almost exclusively in criminal cases. For democracies or would-be democracies, the use of lay jurors in criminal cases seems nearly irresistible. One form this use has taken is the mixed panel of lay jurors sitting with professional judges. Ironically, throughout the common law world, the actual use of juries is in steep decline. While non-common law countries have added lay jurors in criminal cases, common law countries are replacing criminal jury trial with plea bargaining and non-jury proceedings. And except for the United States, common law countries have virtually abolished civil juries. As Alexis de Tocqueville, the French commentator on American democracy, put it in 1835, the jury system arose in the infancy of society, at a time when only simple questions of fact were submitted to the courts, and it is no easy task to adapt it to the needs of a highly civilized nation, where the relations between men have multiplied exceedingly and have been thoughtfully elaborated in a learned manner. Many writers quote Tocqueville on the benefits of the jury, but they forget his warning. The future of the jury will depend on finding ways to incorporate lay decision-makers that are efficient and acceptable to judges and lawyers. Legal professionals have many ways to subvert lay participation in deciding cases, if they find it in their interest to do so. Clearly, however, there remains a strong popular sense in many countries that lay participation in deciding criminal cases is desirable or necessary. Working out ways to incorporate lay decision-makers into criminal cases seems worth the considerable challenge. Chapter 1. Why Use Lay Jurors? The Ancient and Medieval World. Societies at different times and places have had various reasons for using lay jurors. Ancient societies had to find ways to cope with a huge divide, that between the few and the many. In most of these societies, a small and often hereditary elite enjoyed concentrated wealth and power. This elite provided order, learning, and continuity in the state. Meanwhile, the vast majority of people who were not enslaved produced goods and services as small farmers, hired laborers, servants, or craft workers. Each of these groups could threaten the other. The few could oppress the many, but the many had numbers and thus power on their side, if they acted together. The resulting conflict in society could produce instability and eventually chaos and disillusion, often by conquest from outside. For society to flourish, or even continue, the few and the many had to reconcile. Athens developed a powerful form of control over elites, the popular jury. The reforms of the statesman Solon in 594 BCE began the development of popular juries that continued right up until Macedonia ended the Athenian democracy in 322 BCE. For many Athenians, the jury was an important element, perhaps the key element of Athenian democracy. Ancient Athenians considered these juries a more potent form of the people's power than even the popular assembly, which elites could more easily manipulate. In his Politics, Aristotle stressed the Athenian people's control of the courts as the main source of its power. The orator, Demosthenes, argued that juries were the only protection the people had against oppression by the elite. Such was the popular Athenian attachment to juries that playwrights could not resist poking fun. In Aristophanes' play The Clouds, a character looks at a map of Greece and fails to find Athens because no jurors are shown. In his play The Wasps, the main character is a down-at-the-heels old man, addicted to serving on juries. The character revels in the small daily stipend for jury service, less than a laborer could earn, plus the excitement of hearing a case and the feeling of importance when he votes on the decision. Athenian popular juries were vastly different from modern juries in their composition and discretion. The Athenian juries were designed to be as direct an expression of the will of the people as possible. Jury service was open to all male citizens 30 years or older. Each year, a judicial roll of 6,000 potential jurors was chosen by lot from volunteers. Once selected for the judicial roll, the citizens swore the judicial oath and received an official nameplate. Over time, the selection of jurors for cases was randomized. Each court day, those who wanted to serve as jurors showed up outside the courts at dawn and handed in their nameplates. Jurors would then be chosen for particular cases by lot. Between 200 and 1,500 jurors decided a case, depending on the subject. On any given court day, between 1,000 and 2,000 total jurors were needed. Neither the litigants nor the magistrate could remove any jurors from the panel. There was no mechanism for striking or questioning jurors. The large numbers and random selection occurring on the day of decision made it difficult for parties to bribe, intimidate, or pack the jury. The jurors decided an enormous range of cases. These included trials of persons who had public responsibilities for misusing authority. Jurors did not spare leading citizens. Athenian politicians spent a lot of time defending themselves in court, and virtually all important politicians were convicted of something at some point. Even Pericles, the leader of Athens during its golden age and the beginning of the Peloponnesian War with Sparta, was accused of theft, convicted, stripped of his generalship, and heavily fined. The people reinstated him soon after, but they had made the point that they were in control. Perhaps the most famous Athenian convicted in a popular court was not a politician, but a philosopher, Socrates. In 399 BCE, Socrates was accused of impiety and of corrupting the youth. According to Plato, In his defense, Socrates tried to teach and to persuade the jurors about the true nature of justice in judging. His attempt failed, as the jurors narrowly convicted him. Next, each side proposed a punishment. At first, Socrates suggested that he receive meals at the public expense, but he ended by arguing for a small fine. The jurors were not amused. They overwhelmingly adopted the prosecutor's proposal: death. The amount of discretion afforded these jurors is astounding. In each case, there was a trial-like proceeding with evidence. No case could last longer than a day. But within those constraints, the litigants were almost entirely free to present any evidence they liked. A litigant's prior military service, the generosity of his family to the city, his or his family's reputation, all were fair game. Litigants even brought weeping children onto the speaking platform. Not only did the jurors hear all sorts of evidence and have the ability to make of it what they would, but they were almost entirely free to decide questions of law. The laws of Athens were notoriously vague. They did not define the elements of a crime. An example is a law of 410 BCE. If anyone wrongs the people of Athens, then that man, while chained up, is to be tried before the people, and if he is found guilty, he is to be killed by being thrown into a pit, and his money confiscated, and a tithe to be given to the goddess. It was wholly up to the jurors to decide what wronging the people meant, just as it was up to them to decide what was treason, or impiety, or corrupting the youth. Immediately after both sides presented their cases, the jurors voted. They did not formally discuss the case, or as we would say, deliberate, at all. This was to prevent an effective orator among the jurors, or simply peer pressure, from swaying the votes. The idea was that each juror should decide for himself, free from influence, so that the verdict would reflect the sum of each juror's independent opinion. Juror voting was by secret ballot, and the courts used procedures carefully designed to ensure that secrecy. The method evolved over time. By 345 BCE, each juror had two small bronze ballots, one with a hollow axle representing a verdict for the prosecutor, and one with a solid axle representing a verdict for the defendant. The juror dropped his vote into a bronze urn, and the discard into a wooden urn. With the ballot held between the juror's thumb and forefinger, it was impossible for an observer to tell which was which. A majority of votes sufficed to convict. Following a conviction, the jury heard additional speeches and decided on punishment if the law or decree did not specify it. There were no appeals from the decision of the jury. This way of deciding cases is far from modern notions of the rule of law. Most of us prefer our laws to be more precise and their application more predictable. Precision and predictability were not the goal of the Athenians in the popular courts. It is fair to say that Athenian juries were one of the most radical expressions of democracy the world has ever known. The discretion of jurors was so great that the Greek word for jurors, dikastai, is translated as both jurors and judges, often interchangeably by the same translator. The Athenian idea was that a wrong was whatever most people at the time thought it was. Discovering what most people thought at any given time was the purpose of the huge randomly selected juries, enormous discretion over fact and law, and secret ballots with no appeal. The Athenian jury thus represents an extreme pole on a continuum of popular involvement in judicial decision-making. It had the advantage of allowing the people to control powerful elites directly and firmly. It also had disadvantages. Such a freewheeling idea of law and justice, defined by the people in the moment, made stable, effective government difficult. It also, as the case of Socrates demonstrated, could be used to suppress nonconformist views. Drawing on local knowledge, on the cheap. Other societies have not had as extreme a view of popular lawmaking as the ancient Athenians, but they have used ordinary people to decide cases. Traditional societies throughout the world have relied on groups, often an entire village, to pronounce judgment. This was true among the Germanic tribes, in Russia, in China, and in countless other places. Law was customary, built up of practices that had developed over time and that provided stability for the group. Ordinary persons readily understood and could apply these customs, and they were likely to be familiar with the facts, as everyone knew everyone else in these small societies. It is tempting to view the common law jury in medieval England as a simple outgrowth of this tradition, but the reality is more complex. The medieval English jury, from which so many modern practices descend, was in fact the result of decisions by Norman kings. Many myths surround the origins of the English common law jury. Myths that persist among educated people today. Antiquarians and historians attributed the development of the common law system, and especially the jury, to the Anglo-Saxons. This myth began as far back as the late 16th century. In the 17th century, opponents of royal absolutism, such as the judge and then Member of Parliament Sir Edward Coke, eagerly picked up the idea that jury trial and other elements of the common law system predated the Norman King William's conquest of England in 1066. In the minds of Coke and others, such an early origin meant that the Norman kings and their descendants could not take away the ancient liberties of Englishmen, including jury trial. The myth caught on in the American colonies in the late 18th century as they struggled against British imperial control. Thomas Jefferson took up the theory with his usual enthusiasm, to the point of writing an Anglo-Saxon grammar and recommending that the study of Anglo-Saxon be required at the university he founded, the University of Virginia. In his mind, Anglo-Saxon was the language of liberty. In the 19th century, Romantic nationalists and advocates of pan-Teutonic solidarity imagined gatherings of free common men under great trees in England and Germany to decide disputes. The myth grew up that the Anglo-Saxons developed the institutions of liberty, including jury trial and parliament. The myth assigned a black hat. The usurping Norman kings did their best to undermine these free institutions and to substitute their personal, often tyrannical, rule. But these accounts of Anglo-Saxon liberty and the origins of jury trial were wrong. The common law jury originated not with the Anglo-Saxons, but with the Norman kings. In fact, with a very French Norman king. If anyone could be said to be the originator of the common law and juries, it was King Henry II, reign 1154 to 1189. Henry II represented the polar opposite of the Anglo-Saxon dream so many later cherished. His father was French. He was born in France, and he was mostly raised and educated there. He spoke only French and Latin, though he probably understood English as well. According to chroniclers, he was good-looking, red-haired, and freckled, with a large head and a short, stocky body. He was bow-legged from a life in the saddle. Often he was shoddily dressed, but he was well educated by several prominent academics. He had remarkable energy and drive. His lifelong passion was to regain and cement control over the territory ruled by his grandfather, Henry I of England. In this, against the odds, he succeeded. His judicial reforms were a large part of his success. When Henry II took the throne in 1154, he faced an administrative and legal disaster. The country had just been through a long period of civil war, aptly called the Anarchy. The royal finances were in shambles, and so was the system of royal justice. Criminal justice had deteriorated. Local lords had seized power from the crown. Even in normal circumstances, the major forms of criminal accusation and trial had grievous shortcomings, but the anarchy had magnified their weaknesses. Before Henry II, the main form of criminal accusation for serious crime was the appeal of felony. The victim, or a close relative of the victim in the case of a homicide, had to make an individual accusation against a particular person. If the victim and the accused were both men, they had a trial by combat. This was done with swords and shields, and therefore often fatal. If for some reason the accused lost but did not die in the combat, he was immediately executed. To the modern mind, this method of trial seems baffling. It must be understood as a method of ordeal in which God was called upon to give judgment to the combatant who was in the right. Henry and others saw that it could be abused. A thug skilled in fighting could take advantage of this system in several ways. He could accuse another falsely, extort a settlement or win the combat, and proceed to intimidate everyone else in the neighborhood. He could also commit crimes with impunity, knowing that no one would dare to accuse him and fight him. Henry took seriously the king's obligation to dispense justice, particularly after such a period of upheaval. The provision of justice had to improve, but how exactly could criminal justice be fixed? One possibility was to rely on royal officials, professional judges, to investigate and to collect accusations. The Roman Catholic Church had already begun to develop such a system, but this system did not reach England through the church courts until the 1180s. Henry II needed a method he could use immediately in the 1160s, when he was trying to consolidate power and to rebuild the administration of justice. Furthermore, Henry strongly preferred a system that was cheap. He had extensive domains in France as well as his English kingdom to administer, and he was reluctant to spend a lot of money to train and maintain many royal officials if he did not have to. What to do? The solution he and his advisors hit upon was to use groups of local ordinary persons to make the accusations. Groups of men from the locality, including each village, would be gathered together, put on oath, and forced to say whether anyone was suspected of being a criminal. These men would not be paid. The jurors would make their accusations, known as presentments, mostly before the sheriff of each county, when he presided over the local court twice a year. Later, the name of the accusation was changed to an indictment. Here is the origin of the grand jury, and indeed of the entire jury system. Henry and his advisors did not invent the idea of collecting groups of men and putting them on oath to give information. There were precedents, particularly in Germanic kingdoms, for using such groups. These were known as inquests. In the 9th century Frankish Carolingian Empire, such groups were convened to give answers about a range of topics of royal interest, including fiscal matters and military preparedness. The Anglo-Saxon kings of England used similar methods. So did Henry's great-grandfather, William the Conqueror, who used this technique to make inquiries about landholding and population that were recorded in the Domesday Book, 1086. But these were all ad hoc inquiries made at particular times to get specific information when needed. To Henry and his counselors, it was not such a stretch to apply the method of inquest to making criminal accusations. But what was different, Henry's true innovation, was to make these inquests regular and uniform. This was the beginning of accusation by the public. Group accusation helped to solve the problem of local thugs intimidating individual would-be accusers. This solution also saved the English kings money. Here were ordinary men who were not paid for doing this job. They were fined, though, if they failed to show up or failed to present, that is, to accuse, all those who were suspect. the early jury system, and later ones too.
Sample complete. Ready to continue?